Hello, dear student. Very good evening to all of you. So, dear student, please confirm whether my voice is audible or not, so that without any glitches. Yes. Hello, dear student. Once again, very good evening to all of you. So, dear student, our quality discussion. We're going to discuss 20 question, 20 to 25 questions daily. So, that is what very important for your OPSC examination. Of this question. Rather, we are going to see the analysis, why this option is, what are the backward linkage, and other things, all these related topics. So that is what going to be very helpful for your, OPSC prelims examination. So dear student, already there is a available the PYQs, you can watch that. So first question of the day is talking about which four amendment, which four which four amendment to the Indian Constitution give below are related to the scheduled caste and scheduled tribe in India. So which four below are related to scheduled caste and scheduled tribe? So first 8, 19, 29, 46, 65, 95 and 102. So if you look into first constitutional amendment, so first constitutional amendment we have introduced in 1951. So that provide foundational protection and welfare provision, also including modification to fundamental rights to enable the affirmative action. So what is affirmative action? Affirmative action is nothing but the reservation. So we have enacted this first constitutional amendment act to provide reservations to the scheduled caste and scheduled tribe. So one first option is say right. So next one is about the 8th constitutional amendment act. So it was introduced and extend the reservation system for scheduled caste and scheduled tribe in legislative body, ensuring their political amendment also associated with the scheduled caste and scheduled tribe. So next important amendment is 65th Constitutional Amendment Act. So establish National Commission for Scheduled Caste and Scheduled Tribe as a constitutional body to monitor their welfare and safeguarding their right. So you can say that 65th Constitutional Amendment Act we have established for the National Commission for SC, National Commission for the ST, for welfare of the scheduled caste and scheduled tribe. So next is about the 95 Constitutional Amendment, further extend the reservation system for scheduled caste, scheduled tribe in local bodies and legislative assembly, ensuring their continued representation in the democratic structure. So these four constitutional amendment basically deals with scheduled caste and scheduled tribe. So answer is A, 1, first constitutional amendment, 8th, 65th and 95th constitutional amendment basically give power to empowerment of the scheduled caste and scheduled tribe. So next important question, dear student, which of the following statement are not correct? So here the word is very important, not correct. So lot of question OPSC is asking by question itself is not correct. So you have to tick not correct. Okay, be careful on that. Okay, so yes, so in respect of right to privacy, so 9 judge constitutional bench that declare right to privacy as a fundamental right was headed by the Justice Keher. So actually, this is right. This statement is right because Justice Keher, it's a nine-bench justice. The Supreme Court judge bench is nine-judge bench. They have delivered a verdict that right to privacy is included under Article 21. Okay, it's right. The Supreme Court gave this historic verdict in 2018. No, it's actually 2017. So this statement is wrong now. So J.S. Keir was the former 42nd Chief Justice of India. No, J.S. Keir is the 44th CJI Chief Justice of India. This is also wrong now. And he was appointed as the Chief Justice of India in year 2017. Yes, this is right. So 2 and 3 is the answer. I think here it is wrongly given. So I think 2 and 3. So answer is C. Answer is C. Okay, 2 and 4. Okay, so you can see about on the year 24th August 2017, 9th judge of Supreme Court bench of India declared that right to privacy protected as an intrinsic part of the right to life and personal liberty under Article 21. So under Article 21, it's talking about right to life and personal liberty. So this statement is correct. And on August 2017, Supreme Court gave right to privacy verdict. So it is given in 2017, not in 2018 as given in the question. And J.S. Keher is the 44th Chief Justice of India. So appointed 4th January 2017 to 27 August 2017. So is the first Chief Justice of Sikh Chief Justice of India. And statement 3 is not correct and 4 is correct. Okay, so answer is 2 and so it is asking na which of not correct. So sorry, it's 2 and 3 hoga. So 2 and 3. Okay, not correct. That means 2 and 3. So answer is D. So answer is D. So dear student, very careful because in you can see here even a lot of confusion are there. So how you are going to approach this question? First, read this question and which statement is right, which statement is wrong. Just note them down. Here it is right. Here it is wrong. Here it is wrong. It is right. So then you read not correct. It is given not correct. That means 2 and 3. So answer is D. So answer is D here. Okay. Like that you have to remove your accuracy because a lot of student I've seen, so they have given wrong answer because they've wrongly interpreted. So which of the following not included Article 19 of Indian Constitution? So which of the following is not included in Article 19? So I think you know that Article 19 is talking about freedom of speech and expression, movement, association, so all these things. So the freedom from the detention, so this is not included in Article 19, rather it is included on the Article 21. So Article 21 is provided for right to life and liberty. So that is what also include freedom from the detention. So Article 19 does not explicitly provide freedom from the detention. Article 19 1D guarantee freedom to move freely throughout the India. So Article 21 protect the life and personal liberty, which includes protection against arbitrary detention also. So your life and personal liberty also include protection against the arbitrary arrest and detention. So if you look into the sixth fundamental right under Article 19. So first one is about the freedom of speech and expression. That means you have to you can express your thought, opinion, belief freely. So next one is about the right to freedom of assembly. So you can assembly peacefully without arm. So freedom of associations also include form association, union and cooperative society. So from here we are also deriving the cooperative society. So Article 19(1) and C is providing for the cooperative society. So they can ask about question cooperative society is mentioned in which part of the constitution. Okay, so it is in fundamental right. So next one is about the freedom of movement. So freedom of movement is provided so throughout the territory. Then freedom of resident, you can resident any part of the India also. Freedom of profession, you can practice any profession, occupation, trade and business. So these are the freedom of speech. These are the freedom that is protected under Article 19. So but freedom from the detention is protected under Article 21. Right to life and personal liberty include protection. So next important question is which of the following article of Indian Constitution refer to protection and improvement of environment and safeguarding forest and wildlife? So Article 48A of our Indian Constitution, it is part of the DPSP, Directive Principle of State Policy, talking about the protection of environment and forest. So Article 48A of Indian Constitution is part of the DPSP, specifically stated that the states shall endeavor to protect and improve the environment and safeguard the forest and wildlife of the country. So it is added through 42nd Constitutional Amendment Act in 1976, which is very important. And 42nd Constitutional Amendment Act is also called as mini constitution. So dear student, everything is okay or not? So please confirm my voice is audible or not. So please confirm. Yes, please confirm my voice is audible or not. So next one is about which of the following statement are correct in respect of objective resolution of Indian Constitution. So objective resolution, it is being passed by Pandit Nehru to show that what are the our objective of our constitution, what we are going to achieve from this constitution. The modified version of the objective resolution is nothing but our preamble. Okay, so author of this resolution was B.R. Ambedkar. This option is not correct because it is the Jawaharlal Nehru. So like that, you have to pass tick and cross at the end. You have to answer it. Otherwise, you'll commit a lot of mistakes because OPSC nowadays they are asking question a very tricky way. So which of the following are not correct? So first select which one is correct, which one is not correct. Then only you can able to correct it properly. So it is adopted by the Constituent Assembly in 2nd January 1947. Yes, it is right. Even if you don't know, just leave it. This goal of resolution was declared sovereign socialistic. I think you know that socialistic and secular word we have added in 42nd Constitutional Amendment Act. So that means it is also wrong because we have added letter. So how come it is in the original constitution? So next is resolution letter from the preamble of the constitution. Yes, this statement is right. So you know that these two statements are wrong. So 1 and 3 cannot be the answer. 3 cannot, 1 cannot. So only left is B. In this way, we can answer it. So author of this, the objective resolution, Jawaharlal Nehru, not B.R. Ambedkar. Okay. So I think socialistic and secular we have added in 42nd Constitutional Amendment Act. The next is resolution letter frame as a preamble of the Indian Constitution. So we have modified the objective resolution little bit to make it the preamble of Indian Constitution. Okay. So next important question. So which of the following statement are correct in respect of Constituent Assembly? So Constituent Assembly basically aims to prepare the Constitution of the India. So British given this power to make this constitution by the Indians under the cabinet mission. Yes, this question answer is right. The Constituent Assembly was constituted under the cabinet mission. Yes, it is right. The total strength of the Constituent Assembly is 369. No, it is 389. So 1 less than 390. So 389 is the total strength of the Constituent Assembly. So this factual, it is wrong. So 296 seats are allocated to the British India. Yes, it is right. And 73 seats are given to the princely state. No, this is wrong. We have given 93 seats to the princely state. So how many options are wrong? So this one is wrong. This one is wrong. So you know that first you have to just here it is given correct. Always find the whether it is asking correct or incorrect. Then cross and tick. So automatically you will get the answer. So answer is 1 and 3. So that is answer is D, 1 and 3. Okay. So you can see here it is 389 the strength of the Constituent Assembly. So out of that 93 seats are allotted for the princely states. Okay. Okay, so let's move to the next question. So dear student, if everything is okay, please confirm everything is okay or not in the comment box, so that otherwise it's very difficult for me to understand like my voice is audible or not, anything issue, I'm too fast, slow, any suggestion, you are always welcome. Please go ahead and give it in comment box. चलिए आगे बढ़ते हैं. So they consider the following pair in respect of sources of Indian Constitution and pick up the right matching. So first one is Office of Governor. So Office of Governor in England. No, there is England is centralized constitution, unitary constitutions. So in unitary constitution, there is no need for any governor. Only in federal system, when we have union and state, in that case we need a governor. So we are not borrowed this office of governor from England. Rather, we have borrowed either from, you can say, about 1935 also from the Canada also, because Canada follow almost the Indian, we have followed similar pattern of the constitution as in Canada also. Then Public Service Commission, Government of India Act 1935. Yes, we have borrowed from the Government of India 1935 because in Government of India Act 1935 also provide for the Public Service Commission also. So freedom of trade and commerce from USA. No, it is from Australia. We have borrowed the freedom of trade, commerce, intercourse throughout the territory of India. It is from the Australia. So next is language of the preamble. Yes, it's from the Australia. So this is wrong. This is wrong. Then you have to say that consider the following pair and right. So you have to match the right answer. So that means 2 and 4. So answer is C, 2 and 4. Okay. In this way, if you are following, you'll make sure that high level of accuracy. So last 3 to 4 year of examination, OPSC is playing with a knot. So please don't be in haste and commit mistakes. So please follow in this pattern. Okay. So I'm just adding that. So whatever we have borrowed from we have borrowed from United States. So preamble, written constitution, federal structure of the government and fundamental right, independence of president, vice president, independent judiciary, judicial review, removal of the Supreme Court and High Court judges. We have borrowed from the USA. So UK, nominal head, president, designation of the prime minister, cabinet system of minister, parliamentary form of government, bicameralism, speaker in Lok Sabha, single citizenship. What we have borrowed from Australia, concurrent list, language of the preamble, provision regarding commerce, trade and intercourse. So next, Canada. So idea of federation with strong center, distribution of power between center and state, residuary power with the center. So then next, Ireland. So DPSP, election of the president, nomination member of the Rajya Sabha. So what we have borrowed from Japan, procedure established by the law. So Russia, 5-year plan and fundamental duties. So then Weimar Constitution of former German, so suspension of fundamental rights during emergency. So I've given a list of all these features that we have borrowed from different constitutions. So please remember it, very helpful. So I'll post this PDF in our Telegram. So please join our Telegram to get it. Okay. So link is given in comment box. So please join that group. So I'll post. You can ask me. I'll also repost there also. So which of the following article of Indian Constitution not related to each other? So first you have to mark whether in question it is asking about correct or incorrect. So it is asking not correct. So Article 12 and Article 13, they both are talking about definition of the state. Okay, so they are related. So Article 13 and Article 368. Article 13 is provide law. So according to what are the law or law means. So Article 368 provide for amendment of the constitutional law. Okay. So Article 22 is talking about detention, arbitrary arrested detention. Article 32 provides about the writ issue. So they are related na. But Article 141 it's talking about Supreme Court can make order, make law to ensure complete justice. And Article 214 is talking about establishment of the High Court. They are not related. Rest everything is related. Okay. So not related. So you can say only 4. Answer is okay. So I think there is a wrong. So it's only for B. So you can see the Article 12 and Article 36. So Article 12 define term state. Article 36 also define the state. So Article 13 and Article 368 law inconsistent with the fundamental right, while 368 provide for procedure for amending the constitution. So they are also related. So next one is about Article 22, Article 32 too. Why there are so many wrong? Because OPSC is committing so much wrong. I don't know what they are doing in their official answer key. So I don't know how they are making this question. There are huge amount of wrong answer given in their answer. So that is the reason there are a lot of discrepancies. So don't worry about that. I am going to help you to mention which one is right. So next one is about the Article 22 and Article 32. So Article 22 deals with protection against arrest and detention, while Article 32 provide right to move Supreme Court for enforcement of the fundamental rights. So like these are related, but Article 141 provide for any rules, laws, regulation that is being prepared or made by the Supreme Court is binding on the all court. But Article 214 deals with establishment of High Court in a state. Okay, so that is what it is not related. So answer is B, that is only 4. Okay, so I'll just correct it, don't worry. I'm just mentioning it to show a lot of error are there in the OPSC answer. Chaliye. So next is, so which of the following statement are correct in respect of lame duck politician? So lame duck politician means if there is a politician, so he's lost, that politician is lost, but this occupying office this point is lost, and this point that person have to vacate this seat. So this duration is called as lame duck politician. So lame duck politician is someone who lost an election but continue to serve in their position until their terms end. Okay, so that is what given. So having lost in a re-election bid, so statement first statement is right. So choosing not to seek another term after expiry of his or her term, also same called as the lame duck. Because you are currently in the let's say legislature or MP, so you are MLA or MP, but you are not electing one more time. That means you are holding till the election. So this statement is also right. So no term limit running for particular office again. So no term. So even if there is one times only the MLA or MP can be elected to a particular office, so till their end. So let's say last 1 month of their duration, we can say they are also lame duck, because they are going to resign and they are going to not re-elect. So okay, so this is not associated with So next one is about the abolition of office of his or her terms. So no term limit, so this is not satisfied. Even if there is a term limits, there is nothing related to lambda, so this is not the answer. So abolition of office after his or her office term. So let's say there is a MP or MLA. So after this post, we are going to abolish the MLA MP. Then only we can say that they are going to hold office for the shorter duration of time. So then only we can say these are the lambdas also. So answer is A, 1, 2, 3, 4. So 3 is not the answers, because no term limit running for a particular office again. So even if there is a single term, there is, they also called lambda. If there is a multiple term, they also called as the lambda. Okay, so lambda means you have lost the election, and but you have not yet resigned, because there is some duration after that you will have to resign. So this duration is called as lambda session or lambda duration. Okay, so here you can see lambda politician, someone who lost election but continue to serve their position until their terms end. Okay, so choosing one not to seek another term after the expire of his or her term is also applied to lambda politicians. So no term limit running for a particular office again. So lambda status does not inherently related to concept of term limits. A politician can be lambda regardless of the terms in place. Okay, so even if abolish, this is also called as the lambda. Okay, so next important question is, which of the following statement are correct in respect of the basic structure of the constitution? There is a repetition of this question. Already we have discussed this in yesterday also. So it is a form of judicial review. Yes. So basic structure is a innovations for judicial review. Yes. It is used to test the legality of any legislation by the court. Yes, it is tested by the constitution, Supreme Court, to test whether the law is legal or not. So doctrine of basic structure, that is called BSc of constitution, gave free hand to the parliament to amend any part of the constitution. No, it is restricting the parliament to amend any law. So this is not correct. The Constitution of India define basic structure in a Constitution of India define basic structure in federal. So the first of all, in constitution there is no definition like the basic structure. So it is being invented by the Supreme Court in Keswanand Bharati case. So Keswanand Bharati case. So fourth statement is also wrong. So it is asking correct. So 1 and 2. So if you are following this approach, you will have high level of accuracy. So I think some error is there. So 1 and 2. Okay. So 1 and 2. Okay. So answer is 1 and 2A. Chali. So next I have already written it. So please listen it, read it very carefully. So next is entry 5. Entry 5 of the list 2 of the 7th schedule of the Indian Constitution deals with public order, public health, state pension and local government. So here the answer is public order, but in OPSC, so there is an error in the answer key. So I don't know how they are making this question, but if you look into it, is public order. Okay. So 7th schedule of the Indian Constitution. So 7th schedule of Indian Constitution divide the subject into state list. First is union list. Let's write it union, state and concurrent. So union list having 100 subject, state list is having 61 and concurrent is having 52 list. Okay. So 7th schedule provide for division of the subject into union list, state list and concurrent list. So out of that, in a state list, so entry 5 of the list 2, list 2 is nothing but the state list. So even if not given list 2, so you have to remember list 1 is about the union list 2 is the state list 3 is the concurrent list. So it is talking about the public order. So it is given wrong in OPSC answer key also. So which of the following statement are correct in Article 243 of Indian Constitution? So 243C provide for representation of the chairperson of the panchayat at the village level in panchayat at the district level. That means those who are the chairperson at the village level of the panchayat should given a representation at the district level. Yes, this point is right. For first option is correct. Okay, so next one is the Article 243D provide representation of women to the office of chairperson in panchayat at the village level. Yes, this is also correct. So it's a very very depth question. So if you know it, you can answer it. So next one is about 243I related to power to levy taxes by the panchayat. No, 243I is providing for establishment of the finance commission at the state level. Okay, so this taxes imposition is given under the 243H. 243H is provided for imposition of taxes. So 243J is related to bar court on elections to the panchayat. This is also not correct. So 243O is given the bar from challenging. So you can see about that. So it is here given 243J of Indian Constitution empowered legislature of the state to enact law, maintenance of the account by the panchayat and auditing of the such account. So 243J of Indian Constitution provide for panchayat to maintain their account, to maintain their record and auditing of that record. And 243O is providing for, the questioning of validity of panchayat election and any matter with the election. So that means, it bar the court from questioning the validity of any elections to the panchayat or any matter to the elections. Okay? So these are the provisions. So please, little bit of, OPSC is asking little bit of detail about this provision of Article 243. So that is what very important. So please be careful. Chaliye, next question. Which of the following statement are correct in respect of Election Commission of India? So it is an autonomous legal body. So let's see. So if you can eliminate something. So part 15th XB of Indian Constitution deal with election and election commission. This statement is right. So this is a very factual question. So it's a right. So here it is asking about correct. So first you have to mark in a box. So don't commit any mistake the moment you see whether it is asking correct or not correct, because last question whether it is correct or incorrect. So first you have to put correct or incorrect here. So next is election commission established. Yes, January 25th. Yes, one day before our establishment of our the constitutional republic day. So yes, it is. So Article 328 bar on the interference of the court in electoral matter. It is actually Article 329, not 28. Okay. So while looking into that, answer is 2 and 3. So again, it is given answer OPSC given both D and I don't know. Lot of error are there in their answer key. So lot of error. So because of that, even it's very difficult to correct also. Like I don't know how they are making this question. They have to make multiple review before publishing or making this question also, na. Okay. So I think if you know that, so actually this first point is it's not correct because it's not an autonomous body, it's a constitutional body. So first one is the Election Commission of India is a constitutional body. Okay, so that is the reason it is not correct. So next important question is which of the following committee recommended the creation of Nyaya Panchayat at the village level? So actually it is LM Singh B committee. So if you look into committee system, I have given detail about it. So please read it very carefully. So Balbant Rai Mehta committee, so it is established first. So they can ask about sequence of formation of this committee also. So you have to remember BA, BAGL, BAGL, bag L. Okay, so the Balbant Rai Mehta committee talking about 3-tier panchayat system, like at gram panchayat at the village level, panchayat samiti at the block level, and Jila Parishad at the district level, just like present system. So Ashok Mehta committee, they have recommended 2-tier panchayat system like Mandal Panchayat at the village level, Jila Panchayat at the district level. So official representation of the political party at the all the level of the panchayat. So they are talking about political parties should be participate. Seat for scheduled caste, scheduled tribes should be reserved. So this can be a very good question. Which committee talking about reservation seat for the scheduled caste and scheduled tribe? So constitutional recognitions to the PRI. This is also very important. They can ask, I think, in previous questions, they have already asked it. Which parliamentary, which committee on the PRI talking about constitutional status to the PRI? So it is Ashok Mehta committee. So dear student, by looking into previous year question, we can understand from which area, from which portion they are asking multiple questions. So you can just revise whatever I'm teaching here. You will get a lot of insight. You can get direct question. I think from tomorrow class at today class, I have seen that 4 or 5 questions there is a repetition. So they are talking about regular elections to the panchayat. So LM Singh B committee talking about regular free fair of the election, establishment of Nyaya Panchayat, more financial resources to the panchayat. So these are recommendations. The next is Mohan Kanda committee. So it's primarily deal with issue related to the functioning of PRI and rural governance. Okay. So these are the detailed provisions. So answer is LM Singh B. So next is which of the following statement are correct in respect of Attorney General of India. So I think yesterday we have seen about Advocate General of India. That means you can see OPSC is relating and asking repeated questions. Okay? So Attorney General of India is part of Indian judiciary. No, it's not part of judiciary. So it's part of executive. Okay? So I think under Article 76, if I'm not wrong. Okay? So 76 of Indian Constitution provide for establishment of the Attorney General. Yes, I think yes, I have already written it. So I'm going to explain. So the Attorney General of India appointed by the President on advice of the Chief Justice of India. Same statement, exact statement is asking on the, the Advocate General of India. No, being an executive, so it Chief Justice cannot appoint that. If Chief Justice appoint, then there is a conflict of interest, because the Attorney General is going to appear before the Supreme Court and argue in favor of government. So don't you think that if Supreme Court is appointed, then that is going to be favor to the Supreme Court? So that is what led to the against the separation of power. So Attorney General is appointed by the government generally. So there is no interference by the Supreme Court. So not correct. The term of Attorney General of not fixed by the Constitution. Yes, so term is not fixed. So generally when government is resigned, Attorney General is also resigned. So Attorney General of India has right to take part proceeding in both house of the Parliament. Yes, it is right. It is right. So then you have to see, it's asking about the correct na. So answer is 2 and 3. So answer is B. Sorry, yeah, 3 and 4. Yes, answer is D, 3 and 4. Okay. So statement, I'm just writing it down so you can see. The Attorney General of India is provided under Article 76. President shall appoint the person who qualify to be appointed a judge to the Supreme Court to be Attorney General of India. That means those who are going to be Attorney General should be qualified to the Supreme Court judges. To the Attorney General duties to advise Government of India on legal matter, to perform such duty legal character as may required by the President from time to time. So it's perform the duty. Attorney General shall have right to audience in all court in territory of India. That means Attorney General can attend any court in the territory of India. So Attorney General shall hold office during pleasure of President and shall receive such remuneration as fixed by the Government of India. Okay? So these are the provisions. So you can see about Article 76 talking about Attorney General of India. Okay. So let's proceed to the next question. So which of the following statement are correct in respect of bill introduced in the Parliament? Okay. So if a bill is rejected by the House in Parliament, so it amount to the vote of confidence. No, a bill can be rejected. So that does not mean there is a no confident motion. Even the party, those who are in favor, they can reject that. So that is not okay. So that means first statement is not correct. So next is second statement. The government bill introduced in the House necessitated 15 days notice. No, it is 7-day notice. So if government want to introduce a bill in the Parliament, it need 7-day notice. In case of private member, we need 1 month notice. So in case of private member, what we need 1 month notice. But in case of government, we need 1 week. So the taxation law bill come under the category of money bill. I think you can know about the taxation is related to money bill, even if you can guess that also. Even if you don't know, you know that first two provision, you can just get the answer. 1 and 2 cannot be the answer because it is asking correct. So 1 and 2 cannot be the answer. So only 3, 4. Okay. C is the answer. Okay. So next, very good question. So listen very carefully. It is very important for your upcoming examination also. So which of the following statement are correct in type of majority? Absolute majority is more than 50% of the total strength of the house. Okay. So simple majority more than 50% present and voting. So effective, it's right. It is correct. It is also correct. So effective majority is majority of the effective strength. So effective strength means the means total strength excluding number of vacancies. Yes, this is also correct. So special majority 2/3 of the member of the total strength. No, 2/3, or it can be 50% of the more than 50% of the present 2/3 present and voting, and it should be more than 50% of the strength of the house also. So only the 5 answer is not 5 option is not correct, rest is correct. So I have given a very detailed explanation here. So you just read it. Types of majority. So it's first one is majority for amendment, simple majority, 50% member present and voting. So that means let's say there are 500 seat, so 550 total seat is 550. Let's say hypothetically, so out of that 500% people are present. So out of that, let's say 400 vote. So here the majority, if we have 201, so that means more than 50% present and voting. That means they should present and voting. So if 400 members are there, if we are getting more than 200, in that case simple majority, let's pass the bill. So in case of special majority, so more than 50% of the total strength of the house. So what is the total strength of the house? It is 550 na. So here special majority, that means we need 550 means 275. Yes, 275. So 76. That means it is a special majority. So a majority of 2/3 member of the house present and voting. So 2/3 of, and this should be more than more than, yes, special majority means, more, that should be more than 2/3. And just a second, I'm just rewriting it. So that means, let's say a majority of 2/3 of the member of the house present and voting. So present how much? So 400 are present, sorry, present are 500. I'm just rewriting it. So let's say 500 are present and 400 are voting. So 2/3 of the member of the house that present and voting. So 2/3 of the 400. So what is that value? Okay. So you can say 8. So it is like, okay. So if it is, this value is more than 50%, more than the strength, 276, then only we can say this bill is passed. Okay. So next is special majority and consent of the state. Here 50%. So special majority of the parliament plus half of the state ratification is needed. So next one is about, the other type of majority is about absolute majority. So absolute majority is 50% of the total membership of the house. In this case, our total membership is 550. So 50% more than that is 275 member. If more, then in that case we can say it is absolute majority. So what is effective majority? Let's say out of that 550, so 500% are there and 50 seats are vacant. So if more than 50% of effective strength of the house, so in that case we can say more than 50% means 250 members. Okay. So I think I'm clear on that. So I think a little bit of doubt may be here. So little bit of doubt may be here. So let me clarify once again this area. So so let's say total strength of the house is, let's say total strength of the house is 550. But out of that, let's say 500 people are, present. 500 people are present, but 450 people are voted. So in that case, so 2/3 present and vote ना. So 2/3 of present vote means into 450. 450 से काटोगे तो 300 आपको हो गया. So this is 300 and this 300 should be more than 50% of the membership of the house. So 50% कितना होगा membership? 50% of membership कितना है? 550. So 300 should be more than 50% means 276. Yes. So in that case, then only the bill is passed and not get the approval. Okay. So चलिए. So next बढ़ते हैं. I've already given this table with a lot of, information. So please read it very carefully. So this can be a very good question for your upcoming examination also. So next important question is, which of the following statement are correct in respect of sitting of parliament? So in year 1955, Lok Sabha committee has proposed timetable for parliamentary session with 3-year calendar. Okay. Yes. So if you look into our original constitution, it is talking about, there should not be gap of more than 6 months between two sessions. So that means our parliament has to conduct, parliament has to reassemble or meet within 6 months. Okay. So it suggested that budget session starting from the 1st of May. This one is right. This one is also right. Okay. So it suggested that, winter session should be, this statement is wrong actually. So primary constitutional provision governing the parliament session under article 85. Under article 85 is talking about, Indian constitution mandate president to summon the house of the parliament at least twice a year. So that means 85 is talking about our parliament need to be assembled at least twice in a year. So ensure that no 6-month gap between the last and first sitting of the consecutive session. This article also grant the president the power to prorogue, means end a session, and and also dissolve the Lok Sabha also. So that is the reason our parliament having 3 sessions. Parliament is having, first one is about the budget session, then next one is monsoon session, next one is the winter session. Okay. So if you look into that first statement, yes, in 1955, Lok Sabha committee proposed timetable for parliamentary session in a 3 times in a year. Yes, budget session, monsoon session, and winter session. So budget session, yes, this is the timeline it is given. So it suggests, monsoon session from 1st of July to September, yes, this is what, but in winter it is not that. So date is little bit of modified. You can see 5th November to December 22, not December 15. So it's very factual question. Either you know it, otherwise you will commit it mistake. Okay. So next important question is, which of the following statement are correct with respect to due process of law procedure established by the law? So I think if you have watched my previous lecture also, yesterday also we have discussed the same question. So here under the, so I think I'm just explaining it, listen very carefully. So due process of law is American concept. So here it is talking about, the Supreme Court not only see whether you have followed the procedure or not. It is going to look into the other aspect, like, the law is just, law is fair or not. So if law is just not fair, it is arbitrary, then it can struck down. Okay. But on the other hand, the procedure established law generally followed by India, except few circumstances. Article 21 only we follow due process of law. Rest we follow procedure established by law. That means whenever our legislature they have followed the procedure, all the procedure they have followed. So generally it is accepted in the correct way. Okay. So I'm just reading it out. Under the principle of procedure established by the law, as long as government follow procedure it is established, the action are considered as valid, even if they appear unfair or unjust to the individual. Yes, this answer is right. So this statement is right. So due process of law, so under a due process of law doctrine not only check if law to be deprive life or personal liberty of a person, but also see if law may fair, just or not arbitrary. Yes, this statement is also right. So procedure established by law, so procedure established by the law is American doctrine, and due process of law is a Indian doctrine. Just reverse it. No, due process of law is American concept, and procedure established by the law generally found in India. So Article 21 also include due process of law. I think you know that only. So Supreme Court said in that Menka Gandhi case. So that means, you cannot amend the Article 21. You cannot make any law to kill someone. Okay. So that means, only the Article 21 is having due process of law. Rest of the constitution we follow procedure established by the law. So answer is, 1 and 2 are right, and 3 is not correct. So answer is B. So it is given. So I've already written it very well. So please read it very carefully. You will get a lot of insights. So dear student, so we are generally discussing our, the OPSC last PYQ. I'm going to discuss each and every topics on that. So I'm starting from the polity. So this is my second class. If you want to watch detail, you can watch my first class also. So here we are going to do in-depth analysis of all these things. So please watch it and please do share. If you like this video, please like, subscribe to our channel, and please do share this video with a friend so that more number of students can get benefit. And to make this video, a lot of effort I'm putting. It's taking hours to make presentation, make this answer very interactive. So your love, support, like, watch, so really motivate to provide good content. So that is going to be helpful for your examination. I'm going to tell through this you will going to revise everything. So this discussion is not only about discussion. I'm going to revise each and every topics of your OPSC. So please stay tuned, and please join this class at 8 p.m. daily. So there might be some 5 to 10 minute delay, but be ready at the 8 p.m. So we are going to live it on 8 p.m. Okay. So dear student, we'll have to end here. Chaliye, bye bye. Take care. Again, we'll meet tomorrow at 8 p.m. Till then, bye bye. Take care. Bye.